Most people believe their will controls everything they own. That belief is wrong. And it is dangerous because estate planning is not based on what you meant. It is not based on what seems fair. It is not based on what your family remembers you saying at the kitchen table. It is not based on the emotional logic of who you loved most, who needed help most, or who everyone assumes should receive the asset. Estate planning is controlled by structure. That is the first principle. When you die, the legal system does not begin by asking your family what you intended. It asks a much colder set of questions. How was the asset titled? Was there a contract? Was there a beneficiary designation? Was the asset owned by a trust, or does it have to go through probate? That is the machine. If you do not understand that machine, you can have a beautifully written will and still create an outcome you never wanted. This is why so many families are surprised after death. They think the will is the master document. They think if the will says everything goes to the children, everything goes to the children. They think if the will says a house should pass to a child from a prior marriage, the house will pass that way. They think if the will says one person receives the estate, every account follows that direction. But a will does not control everything. A will controls only probate assets. That sentence should be repeated until it is understood. A will controls only probate assets. If an asset passes by contract, the contract wins. If an asset passes by title, the title wins. If an asset is titled in a properly funded trust, the trust controls. Only what is left, what is not controlled by contract, title, beneficiary designation, or trust ownership, falls into probate. That is where the will speaks. Everything else may move without the will having any practical power. This is why estate planning is really about three simple questions. Who is in? How does the asset legally move from one person to another? Those questions matter more than most people realize, because after you die, there is no opportunity to clarify. You cannot walk into court and say, that is not what I meant. Your family cannot simply say, we all know what Dad wanted. The legal system follows documents, title, and beneficiary forms. It follows structure. It is mechanical. This is both the strength and the danger of estate law. The strength is that clear legal structures can make transfers predictable. The danger is that the wrong structure can produce the wrong result, even when your intention was obvious to everyone who knew you. That is why understanding wills and trusts begins with understanding how assets move at death. There are really three major ways. The first is by contract. Certain assets move because you signed a contract with the financial institution or insurance company. Life insurance is a simple example. A retirement account is another. Payable on death bank accounts and transfer on death investment accounts can work this way too. When you name a beneficiary, you are creating a binding instruction with that institution. At death, the contract executes. The company looks at the beneficiary designation and pays that person. It does not ask the will for permission. It does not ask the probate court to reinterpret your feelings. It does not ask the other children whether they think it is fair. It follows the beneficiary designation. If your will says one thing and your beneficiary form says another, the beneficiary form wins. Every time. That is why beneficiary forms are so powerful and so dangerous. They are easy to fill out. They are easy to forget. They are easy to leave outdated. They are easy to assume will somehow be overridden later by the will. But they may control some of the largest assets a person owns. A retirement, a life insurance policy, an annuity, a payable, on-death account, a transfer. On-death account if you named your sibling 20 years ago on a life insurance policy and later wrote a will leaving everything to your children. The life insurance may still go to the sibling if the beneficiary form was never changed. The will does not fix that. The contract controls. This is how families get shocked. The second way assets move is by title. Title means ownership structure. If you own a house or an account jointly with rights of survivorship, the surviving owner may become the full owner automatically when you die. This is common with spouses. A married couple owns a house jointly. One spouse dies. The surviving spouse becomes the owner by operation of title. Again, the will does not control that transfer. The title does. This can create serious problems in second marriages and blended families. Imagine a man has a child from a first marriage. He later remarries and owns a home jointly with his new spouse with rights of survivorship. His will says, I want my share of the home to go to my child. That may sound clear. It may reflect his true intention. It may even feel morally correct to him. But if the house is titled jointly with survivorship rights, then at his death, the surviving spouse becomes the full owner. The will clause may be irrelevant. No one is ignoring the will. No one is dishonoring him. The legal structure is simply doing what it was designed to do. Ownership structure has already answered the question. Title wins. This is why title must match intention. You cannot fix a title problem with a will after the fact. The third way assets move is by probate. This is the bucket most people think about when they think about estate planning. But it may not be the bucket that contains the most valuable assets. Probate is the court-supervised process of transferring assets after death. If an asset has no beneficiary designation, no survivorship title, no trust ownership, and no other transfer mechanism, then it may become a probate asset. The will controls that asset. The will tells the probate court who should receive it. But the will does not avoid probate. That is another common misunderstanding. A will does not avoid probate. A will is the instruction manual inside probate. In fact, when someone dies with a will, the will is usually submitted to the court to begin the probate process. The court validates it, appoints the executor or personal representative, supervises administration according to state law, and ultimately allows distribution of the remaining assets. So when someone says, I have a will, so my family will avoid probate, that person misunderstands the tool. A will does not keep you out of court. A will tells the court what to do with probate assets once you are in court. That distinction is enormous. Now, let's define the will carefully. A will is a revocable legal document. Revocable means you can change it while you are alive and competent. You can replace it, you can amend it, you can revoke it, you can write a new one if done properly. But while you are alive, the will has no operating power over your assets. It sits there. It does not move property. It does not manage accounts. It does not allow someone to step in if you become incapacitated. It does not control jointly titled property. It does not override beneficiary designations. It does not avoid probate. It becomes operative at death. And even then, it only controls the probate bucket. A will can do important things. It can name an executor. That person is responsible for carrying out the will through the probate process. The executor gathers assets, works with the court, pays final debts and taxes, handles administration, and distributes what remains according to the will. A will can also name guardians for minor children. This is extremely important. If you have minor children, a will is not optional. A trust cannot formally nominate a guardian for your children in the same way. Beneficiary designations cannot do it. A payable on death form cannot do it. The will is the place where you make your wishes known about who should raise your minor children. If something happens to you, a court ultimately has the authority to appoint a guardian, but the will is where your nomination is made. Courts often give strong weight to that nomination, unless there is a serious reason not to. Without a will, you are leaving one of the most important decisions in your family's life to a court process without your clear written direction. So even if you have a trust, if you have minor children, you still need a will. This is why the question is often not will or trust. For it is will and trust. The will may handle guardianship and any assets that accidentally remain outside the trust. The trust may handle administration, continuity, privacy, and asset management. Each tool has a role. The problem begins when people think one tool does the work of every tool. A will cannot override a beneficiary designation. A will cannot override joint ownership with survivorship. A will cannot avoid probate. A will does not reduce estate taxes by itself. A will does not provide creditor protection by itself. A will does not handle incapacity while you are alive. A will is not bad, it is just limited. A tool becomes dangerous when people expect it to do something it was not designed to do. Now, let's make this practical. Suppose a person dies with three things. A will saying everything goes to the children, a life insurance policy naming a sibling as beneficiary, a house jointly owned with a spouse with rights of survivorship. What happens? The life insurance goes to the sibling. Why? Because the beneficiary form controls. The house goes to the surviving spouse. Why? Because the title controls. The will controls only whatever assets remain in the probate bucket. This may feel wrong to the children. It may feel like the will was ignored. But the legal system is not ignoring the will. It is applying the correct structure to each asset. The will never control the insurance policy. The will never control the jointly titled house. This is why good estate planning requires asset by asset analysis. You cannot simply say, I have a will, so I am done. You must ask where each asset sits: contract, title, trust, probate. That is the map. Now let's talk about trusts. A trust is not merely a document. A trust exists when a grantor transfers property to a trustee to be managed for the benefit of beneficiaries. The grantor creates the trust. The trustee manages the trust property. The beneficiaries receive the benefit. The most important concept is that a trust separates legal ownership from beneficial ownership. In plain language, that means the person managing the asset may be different from the person who benefits from it. The trustee has legal authority. The trustee follows the trust instructions. The trustee manages assets, makes distributions, pays expenses, and carries out the structure. The beneficiary receives the benefit that may mean income, support, distributions at certain ages, education expenses, health expenses, or future inheritance. This separation is the reason trusts exist. They allow control over timing. They allow continuity. They allow management during incapacity. They allow privacy. They allow complexity to be handled in advance. They can prevent assets from being dumped all at once into the hands of someone who is not ready. They can provide for a surviving spouse while still protecting children from a prior marriage. They can manage assets for minor children. They can avoid probate when properly funded. But again, every word matters. Properly funded. A trust that is not funded is often just paper. This is one of the largest estate planning mistakes. A person pays to create a revocable living trust. The document is signed. It looks official. It has a binder. It has pages of legal language. The person feels safe. But then the assets remain in the person's individual name. The house was never retitled. The brokerage account was never moved. The bank accounts were never updated. Beneficiary designations were never coordinated. At death, those assets may still go through probate because they were never actually placed into the trust or directed to flow into it. Creating the trust document is step 1. Funding the trust is step 2. Without step 2, the structure may fail. This is why I say estate planning is not about documents alone. It is about implementation. The legal system follows ownership. If the trust owns the asset, the trust can control it. If the individual still owns the asset may not be controlled by the trust. That is the basic rule. Now, there are different kinds of trusts. A living trust is created during your lifetime. It can be revocable or irrevocable. It can operate while you are alive and after. When most people casually say, I have a trust, they often mean a revocable living trust. A testamentary trust is different. It is created inside a will and comes into existence only after death. Because it is created through the will, it is born out of probate. It does not avoid probate. This is a crucial distinction. A testamentary trust can be valuable. For if you have minor children or beneficiaries who should not receive assets outright, the will can say assets should be held in trust for them after your death. The trustee may use the assets for health, education, maintenance, and support. Then distribute the remaining balance at a later age. That can be a good structure for post-death control, but it is not a probate avoidance strategy. A testamentary trust still passes through the court process because the will creates it. So if someone says, I have a trust in my will so I avoid probate, they are misunderstanding the structure. A testamentary trust provides control after death. A revocable living trust can provide continuity during life. Incapacity planning, privacy, and probate avoidance if properly funded. These are not the same. Now, the revocable living trust is the structure many families are trying to understand. A revocable living trust is created while you are alive. If you are the grantor and you are competent, you can typically act as your own trustee, you can manage your assets, you can buy, you can sell, you can amend the trust, you can revoke it for day-to-day life. Very little may change. That is why people like it. You maintain control. But because you maintain control, the tax and creditor consequences are limited. A revocable living trust is mainly an administration tool. It can help avoid probate if funded. It can provide continuity during incapacity. It can preserve privacy after death. It can create rules for distribution. It can simplify administration for your family. But it does not reduce estate taxes merely because it exists. It does not protect assets from your creditors. While you retain control, it does not remove assets from your estate for tax purposes. It is not an asset protection trust in the advanced sense. Control and taxation are connected. If you still control the asset, the IRS generally treats it as yours. If your revocable trust owns the asset, but you control the revocable trust, the asset is still treated as yours. This is one of the biggest myths. People say, I put everything in a trust, so I avoid taxes. What type of trust? That is the question. A revocable living trust does not make your estate smaller for tax purposes. It changes the administration, it can avoid probate, it can create continuity, it can keep matters more private, but it is not a magic tax shield. Some irrevocable trusts can reduce estate taxes, provide creditor protection, support Medicaid planning, or move assets outside your estate. But they do that because you give up control. That is the trade-off. Control gives flexibility. Giving up control can create protection. You cannot usually have full control and full protection at the same time. That is a deep principle in estate planning. Now, why is incapacity such a major reason? Because estate planning is not only about death, it is also about what happens if you are alive but unable to act. Dementia, stroke, serious illness, accident, cognitive decline, a temporary medical crisis. If you cannot manage your affairs, someone needs authority to act without the right documents. The family may have to petition a court for guardianship or conservatorship. That can require medical documentation, hearings, delays, fees, and public proceedings. During that time, accounts can be frozen, bills can pile up, family members can be stuck in legal limbo while also dealing with the emotional pain of your illness. That is one of the worst moments to discover that no one has legal authority. A durable financial power of attorney can help. Every adult should consider having one. It allows someone to act on your behalf in financial matters if you become incapacitated, depending on how the document is drafted. But powers of attorney can be challenged. Financial institutions may reject them. They may be outdated, they may be questioned, they often operate account by account. A revocable trust works differently for assets titled into the trust. The successor trustee is not asking to act as your agent over property still owned in your individual name. The successor trustee steps into an existing role inside an existing structure. The trust already owns the assets. The trustee role already exists. If incapacity occurs, the successor trustee can continue administration according to the trust terms. That continuity can reduce friction. If you recover, control can return to you. If incapacity continues, the successor trustee keeps managing. This can be extremely important for families. The purpose is not only avoiding probate after death, it is making life easier for people you love while you are still alive and need help. That is why I often think incapacity planning is one of the strongest arguments for a trust. Death is final. Probate may be slow or public, but eventually the process ends. Incapacity can last years. The family needs a structure that works during that time. A comprehensive incapacity plan usually includes several documents working together. A revocable trust for assets titled to the trust. A durable financial power of attorney for assets outside the trust and other financial matters. A healthcare power of attorney for medical decisions. A living will or advance directive for end-of-life wishes. Possibly HIPAA releases so doctors can share information with the people you authorize. These documents are not substitutes for each other. They coordinate. The trust handles trust assets. The financial power of attorney handles authority outside the trust. The healthcare documents handle medical decisions. Together, they reduce chaos. Without them, families often end up in court. Now, let's talk about privacy. Probate is generally a public court, supervised process. That means filings can become public records. The will, the executor, certain asset information, creditor notices, and disputes may become visible depending on the jurisdiction. For some families, that does not matter. For others, privacy matters a lot. Maybe there is family conflict. Maybe there are disinherited relatives. Maybe the estate is large. Maybe there are business interests. Maybe there are blended family issues. Maybe the family simply does not want private financial arrangements sitting in a court file. A trust administration is generally private. It may not require the same public court filings. Assets can move according to the trust terms without the entire process becoming a public matter. That privacy is one reason families use revocable living trusts. But privacy alone is not always worth the cost and maintenance for everyone. This is why the structure should match the problem. Now, when is a will enough? A will may be enough when the estate is simple. The family situation is straightforward. Probate is not especially burdensome in your state. Assets are modest. Beneficiary designations are correct. And incapacity planning is handled through other documents. If most assets pass by beneficiary designation, and there is little property that would go through probate, a simple will plus updated beneficiary forms and good powers of attorney may be sufficient. Estate planning should not be driven by someone else's checklist. It should reflect your assets, state law, family structure, privacy needs, incapacity concerns, and cost-benefit trade-off. A trust is not always necessary. There is no virtue in complexity for its own sake. Complexity should solve a real problem. If it does not solve a real problem, it may create cost and maintenance without enough benefit. Now, when does a revocable living trust make sense? It can make sense if you want to avoid probate. Some states have probate processes that are slow, expensive, or burdensome. In those places, a trust can save time, money, and frustration for the family. It can make sense if privacy matters. It can make sense if you own real estate and your estate may need probate in each state where real property is located. That is called ancillary probate. A trust can consolidate administration if the properties are properly titled into the trust. It can make sense if incapacity planning is a major concern and you want a successor trustee able to manage assets without court intervention. It can make sense in blended families, second marriages, or situations where you want to provide for a surviving spouse, but eventually protect assets for children from a prior marriage. It can make sense if beneficiaries are minors, financially immature, vulnerable, disabled, or at risk from creditors. Divorce, addiction, or poor judgment. It can make sense if you want staged distributions instead of giving someone a large inheritance outright at a young age. It can make sense if the family is likely to fight, and clearer structure could reduce the room for conflict. Trusts shine when structure matters. They allow you to decide not only who receives assets, but how and when. That can be very powerful. Let's clear up the major myths. The first myth is that trusts avoid taxes. Revocable trusts do not. If you retain control, the IRS generally treats the assets as yours. They remain part of your taxable estate if your estate is large enough to face estate tax. A revocable trust can avoid probate, but probate avoidance is not tax avoidance. Some irrevocable trusts can help with estate tax or asset protection planning. But the trade-off is giving up control. So whenever someone says a trust avoids taxes, ask what kind of trust. The type matters. The second myth is that having a trust automatically avoids probate, only if the trust is funded. If assets are still in your individual name with no beneficiary and no proper transfer mechanism, they may still go through probate. A trust document alone does not magically capture assets. Funding matters more than the binder. The third myth is that a will controls everything. It does not. A will controls probate assets. Beneficiary designations, joint ownership with survivorship, and properly funded trusts can bypass it. The fourth myth is that testamentary trusts avoid probate. They do not. A testamentary trust is created by the will through probate. It can control distributions after death, but it is not designed to avoid court administration. The fifth myth is that if you have a trust, you do not need a will. Many people with revocable living trusts still need a pour-over will. A pour-over will is designed to capture assets that were not funded into the trust and direct them to the trust after death. Those assets may still go through probate, but the will can make the trust the ultimate recipient. And if you have minor children, you need a will for guardianship. A trust cannot do that job. So even trust-based estate plans often include a will. Now, let's talk about the pour-over will more carefully. A pour-over will is like a safety net. It says that anything still in your probate estate should pour over into your trust at death. That can help align the estate plan if assets were accidentally left outside the trust. But it does not avoid probate for those assets. This is another point people miss. The pour-over will may direct assets into the trust, but because those assets were not already trust-owned, they may still need probate first. So the pour-over will is a backup. It is not a substitute for funding. The best plan is to fund the trust properly during life and use the pour-over will only as a safety net. Now, the funding process itself requires discipline. Real estate must be retitled properly. This usually means a new deed transferring ownership to the trust. It must be prepared, signed, notarized, recorded, and coordinated with local rules. Bank accounts may need to be retitled or assigned depending on the plan. Brokerage accounts may need to be moved into trust ownership. Business interests may require operating agreement review. Vehicles may or may not be worth transferring depending on state law. Retirement accounts usually should not be retitled into a revocable trust during life because doing so can trigger tax problems. Instead, beneficiary designations must be coordinated carefully. Sometimes a trust can be named as beneficiary, but that requires careful planning because retirement account distribution rules are technical. Life insurance beneficiary designations should be reviewed, payable, on death and transfer. On death accounts should be coordinated. This is why estate planning is not finished when the documents are signed. The documents create the structure. Funding puts assets into the structure. Beneficiary coordination makes sure contract assets move the right way. Title review makes sure jointly owned assets do not override the plan. The plan works only when all pieces are aligned. Now, beneficiary reviews are one of the simplest and most overlooked tasks. Every few years, review beneficiaries on retirement accounts, life insurance, annuities, bank accounts, and brokerage accounts. Review them after marriage, divorce, birth of a child, death of a beneficiary, estrangement, remarriage, adoption, or major financial change. An outdated beneficiary designation can defeat your entire intention. Divorce is especially important. Some states have laws that revoke beneficiary designations to an ex-spouse in certain cases, but you should not rely on that without legal advice. The safer approach is to update the forms. Do not assume the will fixes them. It may not. Now, joint ownership should also be reviewed carefully. Many people add an adult child to a bank account or house title for convenience. They think it will make things easier. It may, but it can also create unintended ownership, creditor exposure, gift issues, tax consequences, family conflict, and transfer results that override the will. Adding someone to title is not a casual administrative move. It changes ownership. If you want someone to help manage assets, a power of attorney or trust structure may be more appropriate than making them a joint owner. The right answer depends on the situation, but the wrong answer often comes from trying to simplify without understanding consequences. Again, structure matters. Now let's look at blended families, because they are one of the highest risk areas. Suppose you are in a second marriage. You want your spouse cared for, but you also want your children from a prior marriage to inherit eventually if you leave everything outright to your spouse. The spouse may later change the plan and leave assets to someone else. If you own property jointly with survivorship rights, it may pass automatically to the spouse. If beneficiary designations name the spouse outright, the children may receive nothing. This may or may not be what you want. A trust can create more careful rules. It can provide income or use of assets for the surviving spouse while preserving the remainder for children. It can define rights, responsibilities, timing, and distribution rules. That is where trusts become powerful. They can manage competing obligations. A will alone may not solve the problem if assets pass outside probate or if outright distributions create unintended future outcomes. Now, minor children create another issue. A minor cannot simply manage a large inheritance. If a child receives assets outright, a court-supervised guardianship or conservatorship may be required to manage the money until the child reaches the age of majority. Then, at 18 or 21, depending on state law, the child may receive the money outright. That may be a terrible result. Most 18-year-olds should not receive a large inheritance with no structure. A trust can hold the assets and provide staged distributions. It can pay for health, education, maintenance, and support. It can distribute part at 25, part at 30, part at 35, or follow another structure. It can protect the child from immaturity, bad influences, or sudden wealth. A will can nominate the guardian. A trust can manage the money. For families with children, both functions matter. Now, incapacity planning also matters for younger adults. People often think estate planning is for old people. That is wrong. If you are an adult, you need basic incapacity documents, because accidents and illness do not only happen after retirement. A 25-year-old with no spouse may need a healthcare power of attorney so a parent or trusted person can speak with doctors. A 35-year-old with children needs a will naming guardians. A 45-year-old with a house and retirement accounts needs beneficiary designations and likely a more coordinated plan. The complexity changes with life stage, but some level of planning matters for every adult. Estate planning is not only about being rich, it is about reducing friction for the people you love when you cannot act. Now, let's talk about estate taxes. Most families will not pay federal estate tax under current high exemption levels, though laws can change. State estate taxes or inheritance taxes may apply in some jurisdictions. But for most middle-class families, probate avoidance, incapacity planning, beneficiary coordination, guardianship, and family conflict prevention may be more important than estate tax reduction. This is why many people do not need advanced tax trusts. They need correct structure. They need updated beneficiaries. They need powers of attorney. They need healthcare documents. They need a will. Maybe they need a revocable living trust. Maybe they do not. But they should not buy complexity just because they heard rich people use trusts. The type of trust matters. The problem it solves matters. Now, irrevocable trusts are a different category. An irrevocable trust generally involves giving up control. Once assets are transferred, you may not be able to take them back, because control is reduced or eliminated. The law may treat the assets differently for estate tax, creditor protection, Medicaid planning, or advanced wealth transfer purposes. But giving up control is serious. This is used for select situations: long-term care planning, large estates, business succession, asset protection, life insurance planning, generation, skipping planning, special needs planning, and other advanced strategies. It is not the everyday choice for most families deciding between a simple will and revocable living trust. The everyday decision is usually about administration, incapacity, probate, privacy, and family complexity. But knowing the difference matters because the word trust is too broad. A revocable living trust is not an irrevocable Medicaid trust. A testamentary trust is not a revocable living trust. A special needs trust is not a simple living trust. A tax planning trust is not the same as a probate, avoidance trust. If you hear the word trust, ask which one and why. Now, let's create a simple mental model. A will equals death, probate, and public process. It activates at death. It operates through court. It becomes part of a public proceeding. It can name guardians. It controls probate assets. It is simpler and often less expensive. A revocable living trust equals life, incapacity, privacy, and continuity. It exists while you are alive. It can be used during incapacity. It can transfer assets privately after death. It avoids probate only if funded. It does not provide tax or creditor protection while you retain control. It is more expensive and requires maintenance. That equation is not perfect, but it helps. Will, death plus probate plus public. Revocable trust. Life plus incapacity plus privacy. Then add the most important operational rule. Funding matters more than the document. A trust that is not funded does not do the job people paid for it to do. Now let's talk about family friction. Estate planning is not only about legal transfer, it is about making one of life's hardest moments less chaotic. When someone dies or becomes incapacitated, the family is already grieving, stressed, and uncertain. If the structure is unclear, that pain becomes administrative chaos. Who can access accounts? Who pays bills? Who talks to banks? Who manages investments? Who can sell the house? Who can sign tax returns? Who gets life insurance? Who owns the house? Who becomes guardian? Who receives the retirement account? Who has medical authority? If these questions are not answered before the crisis, the family must solve them during the crisis. That is bad planning. A good estate plan reduces the number of decisions left to grieving people. It does not remove grief. It removes avoidable confusion. That is the humane purpose of estate planning. Now, when you sit with an estate planning attorney, you should not walk in only asking for a document. Do not say, "I need a will," without understanding what problem you are solving. Do not say, "I need a trust," because someone online said everyone needs one. Ask better questions. Which assets pass by beneficiary designation? Which assets pass by joint title? Which assets will go through probate? What happens if I become incapacitated? Is my state's probate process expensive or slow? Do I own property in multiple states? Do I have minor children? Do I have a blended family? Do I need privacy? Do I want stage distributions? Are my beneficiary forms aligned with my wishes? Is my trust funded? Do I need a pour-over will? Do I have powers of attorney and healthcare directives? That is how the conversation becomes productive. The attorney can draft documents, but you must understand the structure well enough to ask the right questions. Now, let's think about what happens if there is no plan. If someone dies with no will and no trust, State intestacy law decides who receives probate assets. This may or may not match the person's wishes. The court may appoint an administrator. Assets with beneficiary designation still pass by contract. Joint assets still pass by title. But probate assets follow state default rules. Default rules are not personalized. They do not understand family promises. They do not know who was estranged. They do not know who cared for you. They do not know who needs protection. They do not know your blended family agreement. They simply apply the statute. If you do not create your structure, the state supplies one. That is a bad trade-off for many families. Now, if you have a will but no incapacity documents, you may still have a major gap. The will helps after death. It does nothing if you are alive and unable to act. Families often discover this during dementia or sudden illness. They need access to accounts, but the bank will not allow it. They need to sell property, but no one has authority. They need to pay bills, but accounts are frozen. They need to sign documents, but the person is incapacitated. Then the court becomes necessary. A guardianship or conservatorship may be appropriate in some cases, but it can be slow, stressful, public, and expensive. If it can be avoided through proper planning, many families would prefer that. That is why a will by itself is often incomplete. It may be enough for death distribution in a simple estate. It is not enough for incapacity. Now, if you have a trust but fail to update beneficiaries and title, you may also have problems. Estate plans age, people change, assets change, financial institutions merge, accounts are opened, properties are bought, children are born, marriages end, beneficiaries die. Trustees become unsuitable. A plan created 10 years ago and never reviewed may no longer reflect the actual life. Estate planning is not a one-time event. It is a system that needs maintenance. Every few years, review it. After major life events, review it. After moving states, review it. After buying property, review it. After retirement, review it. After a death in the family, review it. This is not because you enjoy legal paperwork. It is because another important point is that trust administration after death is still administration. Some people think avoiding probate means there is no work. That is false. The successor trustee still has duties. They must gather trust assets, notify beneficiaries if required, pay debts and expenses, file tax returns, keep records, follow trust instructions, make distributions, and act as a fiduciary. Avoiding court supervision does not eliminate responsibility. It may reduce public filings and court delays, but the trustee still has legal obligations. So choosing the right trustee matters. The trustee should be organized, honest, capable, and willing. They do not need to be a financial genius if they can hire professionals when needed, but they must understand responsibility. Choosing a trustee only because they are the oldest child can be a mistake. Choosing a trustee who has conflict with beneficiaries can be a mistake. Choosing someone financially irresponsible can be a mistake. The role matters. The same is true for executor, guardian, agent under power of attorney, and healthcare decision maker. Do not treat these names casually. These people may control your money, your children, your medical care, or your estate. Choose carefully. Now, let's talk about creditors and asset protection. A revocable living trust generally does not protect you from your own creditors because you still control the trust. If someone sues you, if you owe debts, or if creditors have claims, the fact that assets are in a revocable trust usually does not make them unreachable. This is another myth. After death, certain trust structures may provide some protection for beneficiaries if the trust continues and includes proper provisions. But during your life, a revocable trust is not a personal creditor shield. If creditor protection is a major concern, you need specialized planning and possibly irrevocable structures. Insurance, entity planning, or other tools. Type matters. Now, estate taxes are similar. A revocable living trust does not reduce estate taxes because the assets remain part of your estate. Married couples may use certain trust planning to preserve exemptions or manage estate taxes. But the basic revocable trust itself is not a tax reduction tool for most people. If your estate is large enough to face federal or state estate tax, you need specialized planning that may involve irrevocable trusts, lifetime gifts, charitable strategies, business planning, and other tools. Do not assume your revocable trust solves it. Control equals taxation. That principle appears again. Now, what about probate itself? Probate is not always terrible. In some states, probate may be relatively simple, cheap, or streamlined for modest estates. In others, it can be slow, expensive, public, and burdensome. This is why state law matters. The same estate plan can have different benefits depending on where you live. If you live in a state with easy probate, a will may be enough. If you live in a state with difficult probate, a trust may be far more attractive. If you own property in multiple states, the trust may avoid multiple probate proceedings. The goal is not to hate probate in every case. The goal is to decide whether avoiding probate solves a real problem for your family. Now, let's think about cost. A will is usually simpler and a revocable living trust usually costs more and requires more work because assets must be retitled and the plan must be maintained. Cost matters. But cost should be compared to the problem being solved. If probate would be expensive and slow, the trust cost may be worth it. If incapacity planning is a major concern, the trust may be worth it. If privacy matters, it may be worth it. If you own multiple properties in different states, it may be worth it. If none of those issues apply, a will plus beneficiary designations and powers of attorney may be enough. The right plan is not the most complicated plan. It is the one that solves your actual risks. Now let's address the phrase fully under your control for revocable trusts. When you create a revocable living trust and serve as your own trustee, you often continue managing assets almost exactly as before. You can sell a trust-owned house, move accounts, change investments, amend the trust, or revoke it. That flexibility is why revocable trusts are common. But the same flexibility is why the trust does not provide the advanced protections people sometimes imagine. The law sees control. If you can take the assets back, change the terms, and use the money, then for tax and creditor purposes, the assets are still effectively yours. Again, this is not a flaw, it is the bargain. Revocable trust equals control and administrative benefits. Irrevocable trust equals less control and potential protection benefits. Know the bargain before you sign. Now, let's think about special needs beneficiaries. If a child or adult beneficiary receives government benefits due to disability, leaving assets outright can create problems. An inheritance could disqualify them from needs-based benefits. A properly drafted special needs trust can preserve access to benefits while providing supplemental support. This is a specialized area. The source did not go deep into it, but it fits the broader principle. The distribution structure must match the beneficiary's life. A will that gives assets outright may be simple, but it may be harmful if the beneficiary cannot manage money, has creditor issues, receives public benefits, is going through divorce, or is vulnerable. Trusts allow more careful design. Now, what about minor children in a revocable trust plan? Parents may create a trust that says if both parents die, assets are held for children. The trustee can use money for health, education, maintenance, and support. The guardian raises the child, the trustee manages money. Sometimes the guardian and trustee are the same person. Sometimes they are different to create checks and balances. This is a serious design decision. The person best suited to raise your child may not be best suited to manage money. The person best suited to manage money may not be the emotional caregiver you want. Splitting roles can help, but it can also create friction if the people do not cooperate. Again, planning is personal. Now let's focus on the most practical steps someone should take. First, list every asset: home, bank accounts, brokerage accounts, retirement accounts, life insurance, vehicles, business interests, real estate in other states, personal property of value, digital assets. Second, identify how each asset transfers today: contract, title, trust, probate. Third, compare that transfer path to your actual intention. If the account beneficiary says one thing and your will says another, fix it. If joint title creates a result you do not want, address it. If an asset should be in the trust but is not, fund it. If a retirement account needs beneficiary review, update it. Fourth, create or update the core documents: will, revocable living trust if appropriate, durable financial power of attorney, healthcare power of attorney, living will or advance directive, HIPAA authorization, guardianship nominations if you have minor children. Fifth, choose fiduciaries carefully: executor, trustee, successor trustee, guardian, financial agent, healthcare agent. Sixth, review the plan regularly. Estate planning is structure plus maintenance. Now there is one more subtle point about intent. People often believe the law should honor intent. In a broad moral sense, that seems right. But in practice, intent without structure is hard to prove after death. Courts cannot easily distinguish true intent from family memory, pressure, conflict, or revision after the fact. That is why the law relies on formalities, documents, signatures, witnesses, notaries, titles, contracts, beneficiary forms. These formalities can feel rigid, but they create predictability. The same rigidity that protects a valid plan can also punish a poorly structured one. That is why you must align your intent with the legal mechanisms while you are alive. Do not rely on people to interpret your intentions later. Write them into the structure. Now let's connect this to the broader idea of control. Estate planning is about control over assets when you cannot personally control them. During life, while competent, you control your property. During incapacity, control must shift to someone you choose. At death, control must shift according to legal mechanisms you created. If you do not create those mechanisms, control shifts according to default rules, court processes, or outdated forms. This is the essence. Who is in control? When does control change? How do assets move? Every estate planning question fits somewhere inside that framework. Now, I want to address the emotional reason people delay estate planning. People do not like thinking about death. They do not like thinking about incapacity. Parents do not like naming guardians because it forces them to imagine their children without them. Adults do not like choosing between siblings as trustee. People do not like discussing money with family. They do not like paying lawyers. They do not like paperwork, so they delay. Delay feels harmless because nothing bad has happened yet. But estate planning is only valuable before the bad event. After death, you cannot sign. After incapacity, you may not be able to amend. After the family conflict begins, it is too late to remove ambiguity. This is another area where the most expensive day is often the day after you should have acted. The cost of planning feels visible. The cost of not planning is invisible until it becomes enormous. That is why rational people plan before emotion makes planning impossible. Now, the most important lesson from the source is that structure beats assumption. Assumption says the will controls everything. Structure says beneficiary forms and title can override it. Assumption says a trust avoids probate. Structure says only if funded. Assumption says a revocable trust avoids taxes. Structure says control equals taxation. Assumption says a testamentary trust avoids probate. Structure says it is created through probate. Assumption says a will is enough for minor children and assets. Structure says the will names guardians, but asset management may require trust planning. Assumption says power of attorney always works. Structure says institutions can question or reject it. While a funded trust creates a stronger continuity mechanism for trust assets, structure is reality. Assumption is risk. Now, how should this be communicated to a family? Start with the asset map. Do not begin with legal jargon. Sit down and list assets. Then identify how each one transfers. That exercise alone will reveal many issues. The life insurance has an old beneficiary. The retirement account names an ex-spouse. The house is jointly titled in a way that conflicts with the will. The trust exists but owns nothing. The bank account has no payable. On death beneficiary, the business interest has no succession plan. The minor children have no guardian nomination. The power of attorney is 20 years old. The healthcare directive is missing. This is how you find the real problems. The law is complicated, but the first diagnostic step is simple. What owns what? Who receives what? Who controls what if you cannot? Now, I want to close with a principle that applies far beyond estate planning. In complex systems, outcomes are created by rules, not wishes. You can wish your assets go to one person, but if the beneficiary form says another person, the form wins. You can wish your spouse and children avoid court, but if assets are in your name alone with no transfer mechanism, probate may happen. You can wish someone manages your affairs during incapacity. But if no legal authority exists, the court may need to appoint someone. You can wish your trust avoids probate, but if it is unfunded, probate may still be necessary. You can wish your family stays private, but if the will goes through court, records may become public. The system follows the structure. That is why good estate planning is an act of love expressed through legal clarity. It is not only about money, it is about reducing confusion. It is about preventing conflict. It is about making hard moments easier. It is about ensuring that the people you trust can act when you cannot. It is about making sure the assets move the way you actually intended, not the way an outdated form or accidental title says they should. If you remember only one thing, remember this: your will does not control everything. The law follows contract, title, trust, and probate structure. If your estate plan does not coordinate all four, then your family may discover after you are gone that the document you trusted did not control the asset you cared about most. That is preventable. Review the beneficiaries, review the title, fund the trust if you have one. Create the will if you need guardian. Set up incapacity documents, use the right trust for the right problem, and sit down with a qualified estate planning attorney while you are still able to make choices. Because after death or incapacity, the system will not ask what you meant, it will ask what the paperwork says.